In today's video, we will talk about the steps in a criminal trial. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know what happens in a criminal trial. We will start with the opening statements, go through the trial to the verdict, and talk a little about post-trial motions. So let's jump right into steps in a criminal trial. The 9 primary steps in a criminal trial are: 1. Opening statements. 2. The prosecutor puts on their case in chief. By the way, in the opening statements, first the prosecutor goes and makes their opening statement, and then the defense attorney makes their opening statement. Then the prosecutor puts on their case in chief, and the defense lawyer is allowed to cross-examine the prosecutor's witnesses as the prosecutor is putting on their case in chief. For example, they might ask all the questions that they want of a witness, but before the witness steps down, the defense then gets to cross-examine that witness. Then the prosecutor puts on their next witness. After the prosecutor rests, in other words, they've finished their case in chief, it's the turn of the defense. Then they put on their case in chief. After the defense counsel rests, then the prosecutor gets time for rebuttal. Then after the rebuttal, the prosecutor makes their arguments and the defense lawyer then makes their arguments. And then the jury receives its instructions from the judge. Then the jury is sent to the jury deliberation room, and they go back there and they argue about the case until they can reach usually a unanimous verdict. When that happens, they have an announcement of the verdict and then post-verdict motions. So let's go into a little bit more depth on some of these stages of a criminal trial. The purpose of opening statements is for lawyers to educate the jury. They're going to try to educate the jury on what happened, what crime the prosecution says the defendant committed, what they're going to prove in the trial, and the defense lawyer will educate the jury on any defenses the defendant might have. They might point out any holes in the prosecution case and protest the general innocence or not guiltiness of the defendant. In the prosecutor's case in chief, there might be direct examination, cross-examination, asking for the admission of evidence. The defendant, at the end of the prosecutor's case in chief, might make a motion for a judgment of acquittal. A judgment of acquittal would be the judge saying, even with the defendant not putting their case on, the prosecutor did not meet their burden of proof of establishing every element of every charged crime beyond a reasonable doubt, so the judge would acquit the defendant, which would mean not guilty. They can go home and go about their life. Of course, it is shocking and rare when a judgment of acquittal gets granted. Usually it's just a formality. Then the defense puts on their case in chief, direct examination, cross-examination, submission of evidence for admission, and they renew their motion for acquittal, and sometimes the defendant will take the stand and testify as a witness, sometimes they will not. It's totally up to the defendant. The purpose of rebuttal is to discredit the testimony of a witness. If the defendant takes the stand, and this is a huge risk for them to do this, rebuttal evidence could bring up things like any previous convictions that they have. Closing arguments. The prosecutor goes first, they sum up the evidence from the trial, and they ask the jury to find the defendant guilty. The defense lawyer goes second. In their closing argument, they try to cast doubt on the prosecutor's case, including specific witnesses and physical evidence, and they ask the jury to find the defendant not guilty. The prosecutor gets a second crack at it with the closing arguments because they have the burden to prove the defendant is guilty beyond a reasonable doubt, so they get the last word, getting to speak again after the defense finishes. Because the prosecutor has very little control over what the defense lawyer says in their closing argument, they might take issue with some things that the defense lawyer said that might have been misleading to the jury, and they want to clear those up for the jury. At the stage of jury instructions, the judge reads the instructions to the jury. There are several parts to the jury instructions. There are general instructions that they read to every criminal trial jury, telling them what they should do and what they're not allowed to do when they're deliberating. And then they will receive instructions specific to that case, to that trial. Examples are the required elements for each charged offense. They're also instructed about the possible verdicts, and the judge will then send them to the jury deliberation room to do their civic duty and to try to reach a verdict. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. And the higher these videos are in the results, the more people I can help. Thank you. So, what happens after the verdict and after it gets announced? If the defendant gets acquitted or found not guilty, the case is over and the defendant goes home. If the defendant is found guilty, the defense attorney usually makes a motion for a new trial. These are usually a formality, as few of these motions for new trial are ever granted. But they have to do certain post-trial motions in order to preserve the right to file an appeal. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video about sentencing after a jury verdict.